Good afternoon, ladies and gentlemen. My name is Daniel Phipps and I'm the Coal Seam Gas and Mining Project Leader with AgForce Projects. And I'd like to welcome you this afternoon to another webinar from the AgForce Projects Landholder Coal Seam Gas and Landholder Support Project. If you're listening online or if you've called in over the teleconference function, can I just please ask you to mute your phone? Otherwise, it may cause some feedback and interfere with the rest of the presentation. As you can see in the left-hand chat box, if you're experiencing any technical difficulties or you're having any problem hearing the sound or the quality of the slides, please feel free to contact the number in the chat box and quote your participant number when you registered, and Redback Conferencing will be able to solve the problem for you. Firstly, I'd like to say thank you for attending the webinar this afternoon, and thank you also for giving us your time to attend. We'll do our best to stay on time and have the presentation finished by 2 o'clock this afternoon. The topic this afternoon is presenting and discussing some of the recent legislative changes to the land access framework in Queensland and the Make Good framework, with a particular focus being on dispute resolution. We'd like to remind you that the information this afternoon is provided to the jurisdiction of Queensland only, and if you are registering or attending from another state or area, that it's important that you contact your relevant state authority for information specific to your region. As I mentioned, the focus of the webinar this afternoon is looking at changes to the land access and dispute resolution framework. Recently, the Queensland Government have made and proposed some important changes that are important for landholders to be aware of. It's critical to note that some of these proposals are still being debated by Queensland Parliament and also parliamentary committees, and as such, these may be subject to further changes as the process continues. AgForce Projects will continue to keep landholders aware of the progress of these amendments and any changes before they come into effect, to ensure that you are aware and understand how these may affect your negotiations or managing activities on property. AgForce we'd like to remind you that AgForce Projects, the information contained within this webinar provides an overview of the current proposals and outlines what these may mean for landholders on the basis if they are successfully passed. Because these are not final, some aspects may be changed as the process continues, but what is presented today is the current and draft wording as it sits. This webinar is being recorded live, and all those who registered to attend the webinar will receive a recording of this webinar, as well as some supporting information that will be placed on our website following the webinar this afternoon. Before we start, I just want to mention a few housekeeping items. This webinar is in listen-only mode, but at any point throughout the webinar, if you have any questions or comments about your experience with managing or resolving disputes or your experience with the framework, please feel free to share these, and then either in the chat box or to contact a staff member after the workshop. My contact details will be emailed along with a recording of the webinar in the coming days. However, in the meantime, please feel free to contact the AgForce office on 3236 3100 or email CSG team at sg@agforceprojects.org.au. Upon registering, most people provided an indication of what they expect to get answered from today's webinar, and I'm confident that we'll be able to cover off on most of these queries. However, like I mentioned, if there are any questions outside of what's addressed in the webinar, or you have any particular questions or concerns about any of the information that is presented, please feel free to contact me via the AgForce office. Thank you again for your time in registering to listen this afternoon, and let's get started with the webinar. Just a reminder that the information contained within this workshop provides a view of the information and should not be used in lieu of legal or other professional advice.
Cancel this one.
To start with, I'd just like to mention some of the presentation key points. So some of the focuses of the presentation this afternoon will be looking at the dispute resolution framework and the current proposal to introduce an arbitration process for the resolution of disputes in relation to Conduct and Compensation Agreement, or CCA, and make good agreement disputes. There's also a proposal to introduce what's called a Land Access Ombudsman, and we'll be outlining the role of the Ombudsman and what position and role they will play. There's also a current proposal that allows landholders to engage professional agronomy advice in the development of a CCA in the negotiation process. As a result of also recent changes, landholders are now entitled to access professional and independent hydrogeological advice as part of make good negotiations if your bore is experiencing an impact or has been identified in the regional model as being impacted. There's also a proposal to introduce a process called case appraisal, which is currently proposed to be as a type of alternative dispute resolution, or ADR. And it's also proposed that the resource company liability will extend to compensate landholders necessary and reasonable costs, even if a CCA or a land access agreement is not reached. The resource company will be liable to cover these costs. Currently, if a landholder or a company develop an agreement and incur costs, and the negotiations do not result in an agreement, then there's no specific or clear obligation on the company to pay those costs. So in talking about dispute resolution and some of these land access changes, it's important to understand a little bit about where the industry is at and where we're continuing to develop. So since we've been running the project in 2011, as you can see on this graph, the number of CSG wells has been increasing exponentially every year. Right through to about June this year, we've got just over or just under 6,000 wells right across Queensland. And as you can see, based on the 2017 annual Groundwater Report annual update, the predictions are for about 18 to 20,000 wells by 2050 as the industry develops. On your screen, you should be able to see two maps. The map on the left shows the information presented by industry into the 2012 regional groundwater model, and the yellow areas indicate production tenures that the industry plan to bring into commencement over the lifespan of the industry, whereas the map on the right-hand side shows a contrast of the planned future development of the industry as in 2017, and you can see that there are some significant changes in the development footprint and profile of the industry as the industry continues to better understand the hydrology and the gas systems and areas and refine where they expect to develop into these areas. Showing a closer example of this map shows you that based on data provided to the Office of Groundwater Impact Assessment, that tenure areas are brought in across a staggered development profile or commencement period, and you can see that tenure areas are brought in scheduled from 2017 right through to 2050. So it's important that we look at some of this information, not to spend too long to dwell on it, but to understand that the industry will continue to grow and expand across Queensland as it moves into production phases. That in terms of where we sit at the moment, there's approximately 6,900 wells, or just under 7,000 wells drilled, and there are predictions that 8,000 wells will be constructed by the end of 2018, with up to 18 to 20,000 wells developed by 2050. So this highlights again the important need for landholders and communities to continue to remain aware of the developments in industry, the amendments and changes in legislation, as well as technology advancements and improvements, and understanding what this means for landholders, but also for communities. And it's great to see we've got a great roll-up to the webinar this afternoon with over 120 people registered. Jumping into some of the updates, I'll first talk about some of the changes to the Make Good legislation before we get into land access and dispute resolution. So there was an act that went through Parliament last year that provided a right for landholders to be reimbursed for their necessary and reasonable hydrogeological costs associated with negotiating a make good agreement. So this is an important aspect to be aware of as landholders in terms of managing dispute resolution processes. if you believe your bore is being impacted or your bore is being impacted, it's important that you first of all contact the responsible tenure holder if you're aware of them, or secondly that you contact the coal seam gas compliance unit to lodge a complaint. If a make good investigation, if a make good agreement is required to be developed, it's important that you understand your ability to engage this professional groundwater advice to assist you in that process. The Act also implements a dispute resolution process for make good agreements and requires that the cost of dispute resolution or alternative dispute resolution, the facilitator, will be the responsibility of the tenure holder for that bore. Another important component is the legislation that landholder rights are also being expanded to include bores that are or are likely to experience an impact or impaired capacity due to the generation of free gas created by resource activity. So this is in relation to gassy bores. Just a question, is everybody able to hear the webinar okay? Is anybody experiencing any technical difficulties? We've just had somebody mention that they're having some audio problems.
Yeah, I can't get mine to come up on my computer.
Can anybody, any other attendees online, can anybody hear the webinar through the online portal? Okay, everybody says that it's coming through okay. Yeah, the person who mentioned that you might not be able to hear through the online portal, maybe just give Redback Conferencing a call on the 1-800 number provided, and hopefully they can provide you with some support. Alternatively, you can listen to the webinar by calling in on that 1-800 number and entering in your participant code to listen to the webinar. But as everybody else can hear, I'll keep going. So as I was mentioning, as part of this process, you're entitled to a make good agreement now as a result of these legislative changes for bores that are experiencing an impact as a result of generation of free gas. So gas increasing in content in the bore because of the access of resource activities. There's also been some slight amendments to the terminology around the make good framework and clarifying that obligations for make good agreements will apply where there is a likelihood of the impact rather than a certainty that the resource company caused or materially contributed to that supply issue. So this is an important update that restores a bit more of the balance in the process for resolving disputes to remove some of the onus of responsibility from landholders more towards providing a balance point of establishing the actual impact of the bore and the likely contributor to that bore from other external activities or influences. In terms of support that's available for landholders during the negotiation process for make good agreements, there's also a really important project that we are great supporters of, which is called Groundwater Net. Now it's a project that's run by the Coal Seam Gas Compliance Unit through their groundwater team, and it works with landholders to support them to equip their bores, to monitor their own bores, and also feed those results into a regional groundwater database. Now it's a really important project because not only does it help to provide individuals with some bore baseline data, but it also helps to fill in the gaps in the regional monitoring network, and that has a benefit of increasing the knowledge base for everybody in the region, and it's also really important and very useful in determining any potential impacts. As part of a funding arrangement, up to 75% of the cost to install monitoring equipment on registered bores within the Strat Basin Groundwater Net area are reimbursed, and that's administered through the Queensland Murray-Darling Committee or the QMDC. As you should be able to see on your screen, the map shows the Groundwater Net areas that the subsidy applies to. And even if your property is located outside these subsidy areas, we still encourage you to contact the CSG compliance unit to see if you can be involved in the Groundwater Net process as well. And it's a really important project that we're encouraging everybody to get involved with, and can be a really great tool in working to minimise disputes between companies and landholders in relation to determining groundwater impacts, and also provides a little bit more of monitoring data into your own portfolio, and also restores a bit of confidence in the process. As part of developing any make-good agreement, we strongly encourage landholders to seek legal and technical advice before they sign any agreement. And obviously, like I mentioned before, recent amendments allow you to engage and the resource company be required to pay necessary and reasonable legal, accounting, valuation, and also now groundwater or hydrogeological advice. So these are important services available to landholders to assist in any disputes regarding a groundwater impact or concern, and obviously also in the formation or development of a make-good agreement. On your screen, you'll see the contact details for the Coal Seam Gas Compliance Unit if you'd like to ask them any questions about groundwater net, and also if you believe that your bore is being impacted and that it's experiencing an impact as a result of CSG or resource activity, then this is the regulatory body that you need to contact to raise those complaints. Moving now into some of the changes to the land access framework. As I mentioned at the start of the presentation, legislation was passed in September this year to develop the pathway to implement the Land Access Ombudsman. Now, the Ombudsman will play a role investigating the conduct of both parties in either a CCA, so a Land Access Agreement or Conduct and Compensation Agreement, or a make-good agreement in terms of helping to resolve disputes. The Ombudsman will be able to give advice to either parties. They'll be able to offer opinions and also provide options to resolve the disputes in relation to those two agreement types. And it's important that we recognise that the Ombudsman will not make a binding decision or not make any binding determination, will not have any authority to do so. They will have the ability to assist parties to resolve those disputes. So there won't be a determinative or arbitrary body in making a determination about a land access complaint or a complaint with a make-good agreement. Government expects the Ombudsman to be operational by 2018, and they will also have a function being able to make recommendations to government about systemic land access issues and particular issues that they see with the land access framework. It'll also be a free service available to both landholders and resource companies, and it'll cover off on all industries. As more information becomes aware of or available in relation to the Ombudsman, we'll keep everybody aware of these details to become available. At this stage, that's the extent of the information that's publicly available. One of the important aspects to note or be aware of with the Ombudsman is that it will only be involved in disputes between a resource company or a landholder in relation to post-agreement disputes. So the Ombudsman will not play a role in resolving disputes or hearing disputes between parties that are still negotiating a land access agreement or are negotiating a make-good agreement. So if you have a dispute that is arising from the development of an agreement, then the Ombudsman at this stage will not be able to hear that matter. They'll only be able to hear matters once an agreement has been signed and there's a particular issue with either the implementation or a compliance or conduct provision of that agreement. And it's also important to note that the Ombudsman will be a separate body to the Gasfields Commission in Queensland. So as I mentioned, as more information becomes available regarding the Land Access Ombudsman, we'll keep everybody aware. If anybody has any experience with dispute resolution between resource companies and themselves, either in the development of an agreement or the application of an agreement, we'd really encourage you to contact the team to share those experiences if you're happy, so that we can continue those conversations with government about how to effectively develop the Ombudsman to ensure that it's providing a useful service to landholders and that it's based on actual experience and provides a productive model. Some other important changes with the land access framework, is a current bill that's before the Parliament, Queensland Parliament, that is also subject to parliamentary committees, and that's the Mineral Water and Other Legislation Amendment Bill. Now, it outlines some important dispute resolution changes and also proposes a number of amendments to both the land access framework as well as the compensation framework for agreements. One of the key points, as we mentioned in the beginning of the presentation, is that MWOLA Bill provides a proposal to extend resource company obligations to pay landholders costs that are necessary and reasonable in engaging a professional agronomist. So this is in addition to legal, accounting and valuation. As I mentioned before, it will also require companies to cover these costs in terms of legal, accounting and valuation that are incurred to negotiate or prepare a CCA, including if the resource company abandons those negotiations. So where there are instances where a landholder and a company have developed or tried to develop an agreement and costs have been incurred by the landholder, previously there was no clear ability to have those costs paid for by the resource company when that didn't result in a CCA. So this has been an important step forward. It will also propose to provide the Land Court with the jurisdiction to determine the liability of parties in determining necessary and reasonable costs for these negotiations. So if there is a dispute between the resource company and the landholder in determining what are necessary and reasonable legal costs, for example, then parties may be able to apply to the Land Court for a determination about what should constitute necessary and reasonable costs in that negotiation process. There's also been a few amendments in terms of the actual, proposed amendments, I should say, in terms of the structure and format of CCA negotiations in terms of the framework. So there's a proposal in this bill that will remove the conference process with an authorised officer, such as through the Department of Natural Resources and Mines, and remove that from the land access process as a type of alternative dispute resolution, or ADR. So what that will mean is that at the moment, if you're going through a negotiation process, you negotiate for a minimum period of time, you then progress, if an agreement is not reached, to a mediation or ADR step, which can include an independent mediator or maybe a conference with an authorised officer with the Coal Seam Gas Compliance Unit, for example. And that process is a prerequisite to reaching the Land Court. The proposals in this bill is that the conference process will still be available to parties, to landholders and resource companies, but it will no longer satisfy the requirements in terms of meeting the Land Court obligations of progressing through a graduated negotiation framework. One of the other key proposals is that either party, or either landholders or resource companies, can refer or elect for the matter to go to alternative dispute resolution. This is ADR, such as with an independent mediator. And the current proposal is that the resource company will be required to pay the costs associated with facilitating that alternative dispute resolution process. So rather than it being the responsibility of the party that elects for the matter to go to ADR, the responsibility will clearly be that of the resource company, which will provide assurances to landholders. One of the key parts of this bill is a proposal to introduce arbitration as a step or a process instead of applying to the Land Court. So the current proposal is that if you go through a negotiation period, you may then progress to the next step of mediation or alternative dispute resolution. If you don't reach an agreement in this step, you can apply to either the Land Court or you can apply to arbitration. But the bill is quite clear in that parties can only choose one of these options, not both. It's important to recognise that arbitration will be voluntary, so both parties must agree to attend, and neither party can be forced to arbitration instead of Land Court. And important that either the landholder or the resource company can apply to arbitration instead of the Land Court. The current proposal states that each party will be responsible for their own costs at arbitration versus land court where costs may be awarded to or against. Some of the conditions of arbitration that landholders should be aware of include the format and limitations of arbitration and before you agree to attending that process. One of the important areas to recognise is there are no grounds for appeal in arbitration. So a decision returned through arbitration, which is called an award, is final and binding with no ability to appeal. There are also specific timeframes within arbitration of a decision being reached within 6 months. And it's also important to understand the ability of the arbitrator to compel information from either party and also the ability to provide full disclosure of information. Diving a little bit more into arbitration, we'd like to reiterate that the current drafting indicates that arbitration will result in a binding decision for both parties and that it cannot be appealed to any other higher level other than technical matters of law. It will be accessible to both parties, and if they agree, either a party cannot be forced. And as I mentioned, costs for the arbitrator and individual costs will be shared equally unless the resource company agrees otherwise to pay these costs or the arbitrator makes a declaration as part of the process. There's also a slight deviation in this process in that the current proposal indicates that parties are able to access arbitration after the minimum negotiation period of 20 business days, but are not necessarily required to previously participate in ADR or alternative dispute resolution before leading to arbitration. So this is a bit of a deviation, whereas currently before you reach the land court, you must go through a minimum negotiation period of 20 business days. You must then go through another minimum period of 20 business days in alternative dispute resolution, and then only after that period has been reached, then either party can elect for the matter to go to the land court. However, with arbitration, the current proposal is that arbitration will be potentially accessible directly after the minimum negotiation period of 20 business days. The legislation does outline that if parties have not previously participated in an ADR process as a precursor to arbitration, but are not a mandatory requirement, then in these instances, the resource company will be liable for the costs of arbitration. So if you go to arbitration, in the initial step, the resource company under the current proposal will be required to cover the cost of the alternative dispute resolution facilitator. If you then go to arbitration, the costs will be split equally unless either the company or the arbitrator agrees otherwise. However, in the instance if you have not gone through ADR, then the company will be required to cover the costs of arbitration. It is a confusing concept to grasp and understand. I appreciate that, and we've also provided a flowchart to try and explain some of this. One of the other components of the bill is that landholders' legal representation will only be permitted with agreement from the resource company, or the arbitrator declares that the landholder will be at a disadvantage if they're not represented. So there must be an agreement from either the resource company or the arbitrator making a decision that you should be represented. Once an arbitrator has been appointed, a decision or award must be delivered within 6 months. As a landholder, through the arbitration process, you're required to discuss with the resource company the type of arbitration that will be commenced. It'll also stipulate the individual or the specific arbitrator that will be appointed, and this is an agreement that needs to be reached between the landholder and the resource company. In areas where an agreement cannot be reached in appointing an arbitrator, then either party or the party that elected for the matter to go to arbitration may be able to refer to an arbitration institute to appoint an independent arbitrator. Now, we've tried our best to simplify some of these changes in a bit of a flowchart process. So in the first instance, you enter into a negotiation period A resource company may provide you with a notice of intention to negotiate. You'll discuss with the resource company and may include your individual lawyer. Now that period will last for a minimum of 20 business days, and noting that these periods are not a maximum but a minimum period. If an agreement is not reached after the minimum negotiation period, there are two options available, or three options available I should say, sorry. The first option is that either party may refer the matter to go straight to arbitration, as you can see on the left-hand side down to the purple box, bypassing alternative dispute resolution. If a party elects for the matter to go to alternative dispute resolution, then this is a process which may be with an independent facilitator or mediator. Under the current proposal, the resource company will be required to pay the costs of this ADR, and this process may include what's called case appraisal, which we'll talk about in the next coming slides. The third option is that either party may elect to attend a department-run conference, and as you can see under this proposal will sit outside the graduated steps of the land access framework, and it will no longer be a prerequisite to either land court or arbitration. So if after one of these steps an agreement is not reached after arbitration, then either party may elect for the matter to go to, after ADR, either party may elect for the matter to go to arbitration or to go to land court, and it's important that the proposal is for one or the other, not both. As you can see under arbitration, some of the points to be aware of is that there are no grounds for appeal. The result will be a binding decision. Parties will share costs 50-50 unless they skipped ADR or the company agrees or the arbitrator makes a declaration. Parties can choose who the arbitrator will be by agreement or by appointment of an arbitration institute, and a decision returned within 6 months. With the land court, there are appeal avenues available following a decision. Costs can be awarded against a party or to a party in terms of this process. There's no minimum set time frame, and the process can take many months throughout it, and there also are set rules of evidence. As a reminder, as you can see in this flow chart, the Land Access Ombudsman is not involved in this process, because this process is for developing a land access agreement or make good agreement, and therefore are not applicable because the Ombudsman is only involved in post-agreement disputes. Part of the current bill is an inclusion of what's called case appraisal. Now the current draft includes an option that landholders or resource companies can apply within the alternative dispute or ADR timeframe to elect for the matter to go to or go through a case appraisal process. Now this may be conducted by an independent party, possibly through a land court representative, and the concept is to review the merits of a case or the details of a dispute and provide a direction about where that may result if the matter was taken further. Now it's very difficult to provide a lot more information at this point about what case appraisal may be, because there's not a great deal of detail included within the bill. So we're seeking some more clarity from the department about exactly what this may mean, how it may be structured and run, who it may be conducted by, and at what point should this process be accessible to parties. Now the current proposal is for case appraisal as a step before land court or arbitration, but that it's included within the alternative dispute resolution process. So technically you may go through the 20 business day negotiation process. So technically you may go through the 20 business day negotiation period. After that period elapses, you then could elect, or the company may be able to elect, for the dispute to move to a case appraisal process where an independent party will evaluate the merits of the case or the details of the dispute and then provide some direction whether there's basis for the dispute or the argument or the case, or whether the area that's being disputed has no grounds or is not a very strong argument. So it's important that we continue to monitor this process and we'll do our very best to make sure that we keep you all aware of what this may mean and what this may influence. And again, this process is subject to a parliamentary committee hearing at the moment, and we're waiting for details to become available. Some other important land access changes that have been developed over the last year or so is there's also now been the creation of a consistent restricted land framework for all resource authority types. And this restricted land framework sets down minimum distances around infrastructure such as houses and bores and water pipelines, and excludes resource activities within that buffer zone. It's important to recognise that this new framework is only applicable to tenures that were granted after the 26th of September 2016, and if a tenure was granted before this period, then this new framework will not apply to that tenure or your individual negotiations. So certainly what we're encouraging landholders to do, if you're having a dispute with the resource company about the location of infrastructure or activities, and you're wanting to know more about this restricted land framework, that we encourage you to contact our team, and we'll be able to find the date of the tenure that the company was granted, and we'll be able to provide you with some clarity about what framework the company is operating under to minimise that disagreement. There's also an ability for landholders to sign what is called an opt-out agreement instead of negotiating a CCA, but it's important to recognise that this is the concept that's been developed and intended only for small-scale prospecting activities. So not for coal seam gas activities or not mining exploration or activities, and certainly if you are being requested or a company is asking you to sign an opt-out agreement as some disputes are arising, we're strongly encouraging you to make yourself aware of what that actually means, and importantly recognise the process for an opt-out agreement operating outside of the land access framework. So importantly, if you are being contacted or asked to sign an opt-out agreement, we encourage you to contact ourselves, the CSG project, or contact the CSG compliance unit or mining registrar. CCAs and opt-out agreements are now recorded on title, and this is already occurring or has occurred already, and that's similar to an easement agreement on your property title. So if there is a CCA over your property, then this will be visible now on property searches. To minimise potential disputes, it's important to recognise that this does not include any details of what's included within that CCA or that agreement. It purely just indicates that there is an agreement over that property, and that as a prospective buyer or interested party, that you should be requesting a copy of that agreement. But many landholders, or most people, are now aware that if there is a CSG or mining company on a property conducting some activities, that there's going to be a land access agreement between the landholder and the resource company, and that you should be looking at a copy of this agreement. So what I want to now talk about is a little bit about the application of these potential changes and what this may mean for you guys, either negotiating agreements in the future or managing disputes on property. One of the important areas we explain to landholders to be aware of is to understand the framework or the requirement to negotiate an agreement. And the first part is that a resource company cannot unreasonably interfere with your lawful activities. So you own your property. If it's leasehold or freehold, you're still an owner or an occupier, and you still obviously have the ability to manage and operate that property. Now, the resources under the ground, whether it's gas or coal or gold, they're owned by all people of Queensland, and the Queensland government has vested the responsibility to manage those resources for the benefit of all Queenslanders, to be able to then provide a tenure or an authority to a resource company to enter your property. But importantly, for advanced activities, for activities that are likely to have an impact, such as drilling wells or clearing vegetation or roads, that the resource company must gain your consent or gain the approval from the land court, or the current proposal from an arbitrator. provide a bit of an explanation, there are two different types of activities. There are preliminary activities, and this is the first category. Preliminary activities are defined as having little or no impact, and these are walking existing tracks or driving existing tracks, taking samples by hand or by survey equipment. These are activities that should not have an impact to your property. Now, under this category, resource companies are not required to develop a land access agreement or a CCA with you prior to property entry. Now, this is in many cases an area for dispute between companies and landholders in understanding this process. So, although you don't have the ability to, a mandatory ability to require a signed conduct and compensation agreement, it certainly does not mean that you do not have the ability to put some conditions on the company in terms of accessing your property, and we'll address some of those conditions in the coming slides. So even though there's no mandatory ability to sign an agreement, it is important that you discuss some specific aspects with the company and also set down some property access conditions. So in order to do this, companies may provide you with an entry notice. Now, for exploration activities, an entry notice is valid for 6 months. They can send that to you by mail or in person, and they must also provide you with a copy of the current 2016 Land Access Code, their full environmental authority, which is in a way a rule book signing conditions to their project, as well as a copy of the relevant tenure resource authority. When we move into the negotiation period for developing a land access agreement, these are for advanced activities. So these are activities likely to have an impact to your property, such as drilling wells or roads or some seismic activities. And before these activities can be conducted, a company must sign a CCA with you, or they must gain the consent of the land court, as you can see in the current framework on the right, or under the current proposal, gain approval from an arbitrator to be able to access your property. As it sits currently, before any changes come in place with the MWOLA Bill, there's a minimum negotiation period of 20 business days. After that, if an agreement is reached, then advanced activities can take place. If an agreement is not reached after that 20 business day period, then the matter may be referred to alternative dispute resolution. So this is ADR, as we've been talking, so mediation, either with an independent mediator or with the Department Representative. That lasts for a minimum, again, of 20 business days. If an agreement is reached, then obviously the activities can be conducted. In the third option, if an agreement is not reached after the minimum period of ADR, then either party can elect for the matter to go to land court, and the land court will make a decision. So the existing framework, if the conditions coming through the current bill, will make some changes to this process, but it's important that at the moment, until these changes come through, and if they do come through or don't come through, that you understand this negotiation process as it sits, and that this framework provides a minimum level of protection to go through minimum periods and not maximum periods, and it's a process designed to provide some level of protection to landholders to avoid being forced into agreements or being forced to land court. In relation to conduct and compensation agreements, or CCAs, it's obviously important to recognise that they have two distinct components. So the conduct provisions of a CCA agreement, as well as determining and setting out compensation. It's important to understand that your CCA is attached to your land, or attaches to your land for the term of the agreement. So if you sign an agreement that is for the next 10 years or for the duration of activities, whatever that may be, then you're binding successive owners of your property to the conditions of that agreement. So it's important that in your negotiation period, and you discuss this with your lawyer, to consider either including a time frame for that agreement and/or a review period into your CCA to periodically review the effectiveness of the agreement, maybe in managing activities on property, or managing conduct considerations of the agreement, or making sure that compensation adequately reflects the actual impact to your property. As we mentioned earlier, resource companies are required to compensate you for your necessary and reasonable legal, accounting, valuation and now agronomy costs if the current bill gets across the line to negotiate and or prepare a CCA. When we look at compensation, there are specific what they call compensatable effects defined under legislation that a resource company is required to compensate you for. And what's important with your lawyer or with your valuer is to determine the potential impact from the proposed activities and be able to classify these into the compensatable effects and use that to justify the compensation that you'll be seeking. In terms of minimising disputes through the development of CCAs, we've been running the project since 2011 and we've engaged with over 6,000 landholders through the project. We've also collected a lot of survey data throughout the project and recorded a lot of interactions with landholders, and a lot of this data has shown us that important to avoiding disputes or minimising disputes is actually understanding the proposed activities. So intimately understanding what are the activities that are proposed, where are they going to be carried out, how long will they take, and what's involved in the process. So many disputes we've seen between landholders and companies is a lack of understanding or lack of detail that's provided about the activity, the intensity of the activity, the duration, the location, and also the potential impact. In these conversations and in these survey data with landholders, many landholders have indicated that activities occurring outside of what was discussed or what was presented in the original scope of the agreements being misrepresented or glossed over. This is a major CCA and relationship complaint with the resource company. So much so that when we conducted a survey earlier this year, over 54% of landholders felt unsatisfied or very unsatisfied with their CCA. And the reasons for this was that they believed that activities were occurring outside the scope of the agreement, or what was being discussed originally was not done, or not enough detail was provided. That there was also limited flexibility within the CCA to manage these areas as they evolved on property, or to update and manage impact to the property as it developed, and also excluding or not effectively managing staff behaviour or contractor behaviour on property. And these areas led to great much dispute between the company and the landholder, and also deteriorated levels of satisfaction with an agreement. So what we encourage landholders to do to try to avoid some of these disputes, again, is to really understand the activities and specifically list the activities. So how many wells are planned to be constructed, or how many exploration holes are to be drilled, where are these, how big are these areas, how long will activities last for, are there any power lines that are being developed, are there any roads or pipelines, how big are these areas. And once you really drill down to the actual extent of the activities, then you can adequately look at the potential impact to the property, and then you can determine compensation. So by clearly understanding these activities, it allows you, as well as, and also the resource company, to better understand the potential impact and to develop ways to better mitigate, manage and compensate. To also help minimise disputes, it's important that you discuss with the resource company the timing of proposed activities, and obviously compare these to on-property activities such as any drought periods, times of harvesting or calving periods, or important timing for planting or ripping. And in understanding the timing of these activities and in relation to yours is an important area to minimising these disputes. What we're seeing also is weed management and biosecurity is emerging as a large concern for landholders, and also a large area of dispute. To assist in this process, we really encourage landholders to consider conducting a weed baseline assessment prior to those activities being carried out, and also to, if possible, get acknowledgement from the company of the pre-activity condition of the property before those activities. It's important to minimise those disputes to really understand the weed management procedure. So what's involved in the washdown process for company vehicles and equipment, to really specify any requirements that you have specific to your property, to make sure that details are recorded. If there is a dispute, that these can be tracked back and produced. It's also important to understand and minimise disputes in terms of how weeds are managed. And one of the emerging areas is to look at the difference of weed outbreaks versus disturbance. So this may be a difference of weed material being brought onto the property through dirty equipment or vehicles as an outbreak, but there also may be areas of weeds that may be spread by the disturbance of activities on the property. So by clearing 10 kilometres of roads or well pads, that clearing activity creates a disturbance and allows weeds already in the seed bank but not established to become a productive issue. And it's important in terms of minimising dispute to understand how these areas will be monitored, how they'll be recorded, and how they'll be controlled. Another large area for dispute is also understanding what is a weed. In terms of a weed, in terms of an environmental weed or an economic weed, or even just specifically understanding what productive pastures you want on your property, and then other seeds or other plants to your property or your business are considered a weed. So this is importantly bringing down some of this weed management process procedure right down to a property-specific level rather than to a very high-level process. What we're also seeing with CCA agreements is that rehabilitation is also becoming an area of dispute between landholders and companies. What this also relates to is understanding the difference between progressive rehabilitation and end-of-lease rehabilitation, and to understand the difference. So progressive rehabilitation may mean progressively rehabilitating a construction site or a drill site, or removing an area for seismic surveys, and that rehabilitation occurs as the project continues, rather than the concept of rehabilitation being at an end of tenure process, so removing infrastructure in 20 years' time. So certainly what we're seeing disputes between companies and landholders is the requirements to progressively rehabilitate areas, and having the ability as landholders and property managers to be involved in that process to make sure the seed material that's being used is specific to your requirements, that they're not actually going to rehabilitate areas or reseed areas with a seed that's conducted as considered a weed to your property, or that is likely to have a productivity impact, for example. It's also important to discuss with the resource company and understand some of the processes around reporting for erosion or subsidence or rehabilitation failures, for example. So there may be many examples where areas have been rehabilitated and conditions may have been signed off, but in years to come or weeks to come or months to come, that ultimately that process fails and starts to create an impact to your property. So again, to minimise that dispute, you're understanding the process that you can be involved in. Are you able to review or sign off on that rehabilitation? Are you putting in place or discussing with the company a period of time that they'll be liable to monitor and review those areas to make sure that they're rehabilitated effectively and return back to a standard that meets your requirements? And obviously the last condition is understanding that if this rehabilitation process takes longer than is expected, then how is this covered in your agreement, or does compensation cover you if rehabilitation takes years and not months, and how is it addressed in terms of minimising that dispute with a resource company? So what we're seeing is a key theme of it's really important to help minimise some of these disputes, is to consider how your property operates, to identify how those proposed resource activities may impact your property, and importantly to develop methods that that are very clear and that work to minimise, manage or monitor that process. Some of you indicated when you registered for the webinar that you had an existing CCA, so you've already signed an agreement and you want to, I guess, bring it back into current best practice at the moment. So under legislation, there is a requirement that if there is a material change in circumstances, such as a significant escalation in activities or impact maybe, then a CCA must be updated to reflect either the change in activities or the change in impact. So we're seeing this as another area for disputes with resource companies and landholders, and really important to minimise or avoiding those disputes is to understand the term of your agreement. So to really understand, is there a specific time frame that your agreement is valid or applies to, either for life of tenure or the duration of activities, and has it expired and is it no longer current? So important to, if in a potential dispute with a company, understand the agreement, and obviously you can contact our team for advice and support in managing that process. It's important really with the agreement to understand what activities it covers. So certainly what we're seeing in terms of disputes is that an agreement may not be very specifically written or maybe too broadly written, and it opens it up for misinterpretation. So if you are in a dispute with a company about activities or the duration of activities or the type of activities, it's important, like I said, to understand the term, but specifically what activities does the agreement cover, and to understand or identify, is this occurring outside of the scope of the agreement. If you've signed an agreement years ago, it's important to look at, does the agreement reflect current practices, and is there an opportunity for you and the company to improve on it and work to find a better agreement. Certainly we're encouraging industry and companies to revisit historical agreements or old agreements with landholders that may have been signed many years ago to bring that into best practice in terms of conduct considerations, technology, and also compensation being paid fairly to reflect the actual impact. So again, if you're in a situation with a dispute with a company and you're not making any headway or progress, certainly we encourage you to contact ourselves or to contact the CSG compliance unit for assistance in that process. Just to summarise at the end of the presentation before we conclude, just to remind everybody that this webinar is being recorded, so you will be sent a full recording of this webinar following the presentation this afternoon in the coming days. We'll also send you an information link to our website which will explain more about these dispute resolution changes and also the ability to access some more information about the Land Access Framework amendments currently being proposed. In summarising the presentation, it's important that you recognise or you're aware now that if you're involved in a make good negotiation or a make good dispute, that you're entitled to access professional hydrogeological advice in those negotiations. There's also a proposal at the moment going through Parliament that will give you the ability to engage professional agronomy advice in CCA negotiations if that passes through Parliament. There's also been the introduction of a land access Ombudsman, and the Ombudsman is expected to be operational by 2018. The Ombudsman will only be involved in disputes after a CCA, so it's a land access agreement or a make good agreement has been signed. So the Ombudsman will only be involved in disputes post-agreement. They won't be involved in developing an actual agreement for land access or make good agreement. There is a current proposal to develop arbitration as a process instead of land court, and we will provide a lot more information about the arbitration process, the different types of arbitrators available, and provide some information to assist landholders if this bill does become legislated to be able to access information about where to find these bodies. Then also the dispute resolution framework in terms of conducting a conference with the department as the result of these proposals will sit adjacent to the land access framework but will still be accessible to landholders, and that resource companies will be liable to compensate your reasonable and necessary professional costs incurred to negotiate an agreement, including instances where the resource company abandons negotiations. And obviously importantly to recognise that both compensation and conduct provisions of an agreement are both equally important. So in terms of the presentation this afternoon, that concludes the information that we need to present. On your screen will be contact details for the coal seam gas compliance unit if you have a specific complaint or anything compliance related you would like to raise with the regulator, and there's also contact details for our CSG and mining team. Before we close the webinar this afternoon, are there any questions or comments that anybody else would like to make? Been a few coming in, and I hope that we've been able to address them as the presentation goes. Certainly, we would like to thank you all for listening to the webinar this afternoon. Appreciate you giving us your time. We certainly appreciate that it's a particularly busy period for everybody, so we do thank you for listening. Like I mentioned, the webinar will be distributed to everybody who registered in the coming days, as well as a link to additional information on our website. There's a lot of information contained within this webinar, and we do encourage you to contact our team with any questions or comments or feedback that you'd like to provide, and appreciate that fairly content-heavy material, but we'd really encourage you to contact our team if there's any questions that you'd like to raise with us. We'll also be sending out our next edition of our CSG and Mining newsletter for October, which will provide a fairly extensive summary and analysis of these legislative changes, as well as provide an update to company activities with these legislative changes, as well as provide an update to company activities within the industry, as well as an overview of the recent tenures that have been released by the Queensland Government to develop a new stage of exploration. So if you're not already registered, we please encourage you to jump onto our website, put in your details to register for the next upcoming edition of the newsletter, as it certainly will contain some very useful information. Thank you all for your time. We will close the webinar this afternoon, and we look forward to seeing you around. Thank you.